Article 1, Section 3 of our Clause 6 of our Constitution, of course, provides in pertinent part that the Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation, and when the President of the United States is tried, the Chief Justice shall preside. By intentionally waiting until President Trump's term of office expired before delivering the article of impeachment to the Senate to initiate trial proceedings, Speaker Pelosi deprived then-President Trump of the express constitutional right and the right under the Senate's own Rule 4 to have the Chief Justice of the United States preside over his trial and wield the considerable power provided for in the rules of procedure and practice in the Senate when sitting on impeachment trials. That power includes, under Rule 5, the presiding officer's exclusive right to make and issue all orders, under Rule 7, to make all evidentiary orders, subject to objections by a member of the Senate. We say respectfully that this intentional delay by Speaker Pelosi, such that in the intervening period President Trump became private citizen, Mr. Trump, constitutes a lapse or waiver of jurisdiction here. For Mr. Trump no longer is the President, described as subject to impeachment in Article 1, Section 3, Clause 6, and in Article 2, Section 4. And this body, therefore, has no jurisdiction as a function of that additional due process violation by Speaker Pelosi. Moreover, with all due respect, then-President Trump suffered a tangible detriment from Speaker Pelosi's actions, which violates not only his rights to due process of law, but also his express constitutional right to have the Chief Justice preside. That tangible detriment includes the loss of the right to a conflict-free, impartial presiding officer, with all due respect. The very purpose behind requiring the Chief Justice to preside over the President's impeachment trial, along with the other benefits of having the two branches combined, the Chief Justice from the judiciary and the Senate, for the impeachment trial of the President, reflected in Federalist 66. One of the reasons the Chief Justice was chosen for that task. Mr. Trump now faces a situation in which the presiding officer will serve as both judge, with all the powers that the rules endow him with, and juror with a vote. And beyond that, the presiding officer, although enjoying a lifelong honorable reputation, of course, has been Mr. Trump's vocal and adamant opponent throughout the Trump administration, and in fact, in the very matter on trial, the presiding officer, respectfully, already has publicly announced his fixed view, before hearing any argument or evidence, that Mr. Trump must be convicted on the article of impeachment before the Senate, and indeed that members in both parties have an obligation to vote to convict as well. Nowhere in this great country would any American, and certainly not this honorable presiding officer, consider this scenario to be consistent with any stretch of the American concept of due process and a fair trial, and certainly not even the appearance of either.